vessel or the judicial side?
Yes, sir.
Is this on the administrative side or the judicial side?
This is on the administrative side, sir.
Then why the word use aggrieved party by a bench of not less than 3 members? The bench is constituted
Yeah, I don't know if this
judicial
is
side or the administrative side.
Taking that point further, I mean, whether at all these straight jackets about this administrative moving into judicial,
The
moving
point
into
is-
administrative.
Probably the bard said it best. The rose by name would smell just as sweet.
I would
So
say,
whatever you call it,
I would say reconsideration and order of your brother judge on judicial applications, if that can be considered as a part of procedure and practice, my lord, then just building on what Justice Munib has said in his opinion, why not appeals as a part of procedural law? So, but that's my alternative. But let me come to my main argument, which is legislative competence as far as appeals are concerned. I rely on entry 55. And like Hassan Azhar Saab's judgment, where he relies on 175(2), the judgment authored by her ladyship Aisha Malik Saiba has also relied on 175(2), read with entry 55 in the CCP judgment, which conferred an appeal to the Supreme Court. So,
See, as pointed out yesterday, there is a difference between bringing an appeal to the Supreme Court as opposed to creating an appeal against an order of the Supreme Court. So when you are relying on examples where the appeal is coming to the Supreme Court, it's different. The whole the way of looking at the law and interpreting the law will be different. The question here is not about can this appeal come to the Supreme Court. It's about whether this appeal under 143 amounts to a creation of jurisdiction or whether it is the enlargement of the jurisdiction. I don't see how any of the issues that you are presenting have answered that particular question.
these are two separate
Mr.
questions.
Faisal, I mean, if the appeal comes through a statute or if the appeal comes through a statute like the Competition Act or the Elections Act or whatever, they are enlarging the jurisdiction of the Supreme Court.
That is
Either way, it goes directly into entry 55.
one of the questions which was raised by Justice Ijaz was that if you create a new appeal, is this enlargement or this is because enlargement would imply something being there that is being enlarged. But your ladyship's judgment includes within the term enlargement in para 62 of the CCP judgment 2021 CLD that enlargement in creation of
can
a
you
new
give me the
appeal.
citation too?
Sir, this is 2021 CLD 214 at para 62-64. But let me come back
Era 62.
to 64. But let me come to, there are two parts to the objection which have been raised. The first part is, where does legislative competence come from? Which end do you rely on? The second part is the problem which your ladyship has raised, which is, what is the constitutional procedure to be adopted to confer this appeal? Whether it's through an ordinary statute or through a constitutional amendment. Let me deal with both objections separately. Let me first come to the objection of legislative entry and legislative competence. If I may draw your lordship and ladyship's attention to entry 50, kindly, it's quite a complicated entry. मैं अगर इसको जरा ब्रेक डाउन करके पढ़ लूं,
अगर आप पढ़ते हुए ये एंट्री 55 को एक दफा दोबारा से पढ़ें,
वही मैं पढ़ रहा हूं सर.
आप उसमें you miss out on the jurisdiction powers of all courts. What do you mean? What is excluded then? अगर हम आपकी बात माने तो फिर तो आप, क्योंकि उसका जिक्र कॉन्स्टिट्यूशन में हुआ है, तो आप उसकी हर चीज को इनलार्ज कर सकते हैं. वो आप बताएं, आप क्या समझते हैं इसके?
और दूसरा इसमें इसी सवाल में अगर पढ़ते हुए टू सच एक्सटेंट एज एक्सप्रेसली ऑथराइज्ड,
जी,
इसके ये ऊपर के साथ पढ़ना है, नीचे के साथ पढ़ना है,
मैं
कहां
मैं
पढ़ना है?
Let us read this entry. Jurisdiction and powers of all courts except the Supreme Court. Now let me stop here. Your lordship, ladyship, may just keep your eye on the word jurisdiction and power because it will occur again, but in a different form. With respect to any of the matters in this list. Now, this of course is not relevant only to the extent that enlargement of jurisdiction and supplementary powers have to be understood by the first part. So it's a different thing which is being talked about in the second part when one is talking about the Supreme. Now, the
और
Supreme-
अंडर से पढ़े ना, और अंडर.
जी. And to such extent as expressly authorized by or under the Constitution. So this is the first condition, that if you want to legislate under this entry, then you need a conferment by or under the Constitution.
So is it your argument that this by or under would bring in item 58?
No, this is not.
Okay.
But there are two restrictions on this entry. It is not an open-ended entry.
So you're saying that this, to such extent as expressly authorized, is to be read on the first part of the entry relating to the high courts and other courts, or to the Supreme Court?
No, second
Or
part.
both?
Second part.
Second part?
Yes.
Okay.
To the Supreme Court part.
Okay.
To such extent as is expressly authorized by or under the Constitution. Now you need to seek this conferment of power from other provisions of the Constitution, either expressed by or necessary implication. But
Entry number
that power,
55 में Mr. Faisal ये जो दो लाइनें हैं ना, with respect to of the matters in the list, ये तो हो गया बाकी कोर्ट्स के लिए.
ये तो कोर्ट्स के लिए हो गया, ये हमारे लिए
से जो
relevant
शुरू हुआ वो फिर आगे सुप्रीम कोर्ट का तस्करा.
जी. अब सुप्रीम कोर्ट.
हाँ, चल, इसके मानी पे extent.
और
अब
इसमें जो express authorization, the words used are expressly authorized by the Constitution. Where do you get the express authorization from?
Yes,
Who explained
but
that?
it is by or under. That critical.
No. You see, express means express.
No.
It can't be implied.
By,
When it says express, then it has to be express.
I'll
You
explain.
can't read
Let
implied
me just
into it.
explain the other two restrictions and then I'll come back to this.
I am really enjoying your physical motions. It makes me a little dizzy, but I'm really
Sir, I'm
refreshing
sorry,
also.
sir. I'm sorry.
No, it's okay. Yeah.
If
It's
you
just
stop
on the
it,
lighter side.
if you stop it, you won't be able to argue.
No. I just find it very refreshing.
Sabbatical 2.
This is the only exercise I get, sir.
Sir, the first restriction is the enlargement of the jurisdiction of the Supreme Court. Now, your lordship will see the difference between the first part and the second part. You can't legislate in relation to all matters in any way when it comes to the Supreme Court. It must be, there is a restriction involved. You have to justify the law as enlarging the jurisdiction of the Supreme Court.
But expressly
But
authorized.
expressly,
Yes.
वो बताएं वो कहाँ है.
उसका क्या
Sir,
मानी
मैं
है?
एक मिनट second part पढ़ लूं. जी. And the conferring thereon supplementary powers. So it's not that you can legislate on any powers of relating to the Supreme Court. It should be a law that confers powers on the Supreme Court, supplementary.
In addition to what is already mentioned.
Ji?
In addition to what is already there.
Yes. So this is a way to protect the jurisdiction and the powers of the Supreme Court. That if the
और दोनों
Parliament
है
is-
ना, एक तो enlargement का दिया.
To such extent as is expressly authorized by or under the Constitution.
Yes.
We understand the enlargement.
Yes.
part.
The way I
So,
understand
इसका क्या मानी है?
yes, the way I understand
Mr.
it,
Faisal,
Ji,
it
sir.
is supplemental powers, not the supplementary powers.
supplemental power जी.
Supplemental
सर
powers.
दोनों की एसेंस ये है कि सुप्रीम कोर्ट को प्रोटेक्ट किया जा रहा है पार्लियामेंट से कि ये पावर्स घटा नहीं सके, ये जुरिस्डिक्शन घटा नहीं सके. तो करना है तो कॉन्स्टिट्यूशन अमेंड करें. स्टैट्यूट से सिर्फ पावर्स को बढ़ाया जा सकता है.
But you are saying कि 55 is not applicable.
As an alternative argument, 50, I rely on 55.
Faisal, I'm
So
not getting the answer.
I
please.
am also not understanding
सर
very
देखिए,
clearly.
मेरी पहली
As Justice Ijaz Sahab has said, कि first condition is expressly authorized.
मैं उस पे वो
So
दिखाऊं.
अगर आप कर दे बता दें
हाँ,
कि
ये
अगर ये
बता-
बात सही
मैं
है
वो
या
बता-
गलत है तो हम
मैं बता-
हाँ.
Sir, I rely on two provisions of the Constitution for this express authorization under the Constitution and by the Constitution.
Hey, how
One-
have you drawn the distinction between by and under?
Under, yes.
How, you are saying by means by the Constitution and under means?
You said under means by implication.
By necessary.
So,
From where have you drawn this? Is this your opinion or are you pulling
My
it
lord,
out of some understanding?
There is a Supreme Court judgment which Indian Supreme Court judgment which I've
No,
cited.
there is a judgment of this court as well, which talks about by or under in terms of Article 240. It has discussed what it is, by or under, what it means. And it says under means, by or under means specifically under the statute, constitutional mandate,
Yes,
like by some rule of the Constitution or given by some mandate of the Constitution.
yes.
So it's nothing implied. So your whole argument that this is something that could be implied, it's not implied. By or under the Constitution means something that is expressly provided for in the
I'm not
Constitution.
saying that it's not expressly provided. When you
में
read,
implication तो कोई भी नहीं.
when you read a certain article,
Article
that
240
conferment of legislative power necessarily follows from, and when I refer to the two provisions, your lordship will see your ladyship will
So
see.
Article 240 related to the service of Pakistan, it is only subject to the constitution.
जी.
इसमें by or under तो नहीं लिखा हुआ।
240A में by or under.
240A
Learned counsel.
जी।
ये बात वैसे ये
I'm
clear
sure
नहीं
I would
हुई।
not
फिर मैं
be
उस आर्टिकल्स पे आऊंगा तो क्लियर हो
ये
जाएगा।
आइए ना फिर उस पे वो एक्सप्रेसली ऑथराइज वाले को तो
directly उस पे आ
हाँ,
जाइए ना जो आपके दो articles.
There are two articles which I rely on for the first condition.
एक्सप्रेसली
One-
ऑथराइज
जी.
जी
First is, if your lordship has read those articles, let me take your lordship again to
Number बता दें।
175(2).
हाँ?
175(2).
ठीक और दूसरा कौन सा है
दूसरा I read with Article 141.
141
It is only the parliament which can legislate.
आप 141 इसमें इंक्लूड नहीं कर रहे
नहीं, वो अगर आप अपील को प्रोसीजर में इंक्लूड कर देते हैं तो 191 read with
175 का 2 जरा पढ़ लीजिए.
सब आर्टिकल 2.
And this is for all courts,
Yes.
including the Supreme.
Yes, and this is how it's been interpreted by His Lordship Justice Hassan Azhar Rizvi. That is where the conferment of appellate jurisdiction comes from. 175(2). No court shall have any jurisdiction save as is or may be conferred on it by the Constitution or by or under any law.
Council, this 175(2) is also of the same category where it restricts. It doesn't expand. It doesn't confer legislative competence. It restricts the power of the court to exercise jurisdiction to what is provided by the Constitution or, in relevant cases, what is provided by the law. It doesn't expand, it doesn't confer legislative competence on anybody.
My lord, I don't read the restriction or expansion in sub-article 2. I don't see that.
It says,
It
no court
simply
shall-
says,
it is
Cast in negative
couched in
terms.
negative terms. No court shall have jurisdiction.
yes,
Which means what? That every court would have only that jurisdiction which is conferred by law of the Constitution.
yes,
So it
but that law
restricts.
can be enlargement of jurisdiction.
Where
validly
the-
enacted under some other provision that's the
Yes.
point
The Constitution is giving competence to Parliament. It's couched in positive words, and it is directly telling Parliament that you can make law on this subject. And those examples were cited yesterday. There are numerous examples.
I think before going to Article 175(2), you have to read Article 142.
141.
142, where the Parliament has the power to make laws. Once laws are made by the Parliament, then no court shall have the.
But those laws have to be related to an entry of the
And
legislative.
191 comes into field and.
with all due respect your argument is circular you see
Yes.
because you start with entry 55 you go to 175(2) and then you bounce back into 175 entry 55
It's a
The
ping
power-
pong
the
day for
law-
you.
Yes.
The law, we are back to ping pong.
It's a ping pong day for
If I may explain
Yeah,
your,
but
because
the law over there has to surely mean if validly enacted law.
Yes.
And for law law to be validly enacted, one cannot look at Article 175(2). One has to look elsewhere in the Constitution. And wherever that may be, a legislative entry, 191, 188, what have you. And that, all of that is the premise of 172. It can't, 175(2) does not of its own, I mean, that's how I understand it, maybe.
My lord, let me just read a passage from a judgment which explains my argument, and then I'll further explain.
Faisal ji, I'll just read this sub-article 2 again. No court shall have any jurisdiction save by or under any law. Now, it's speaking for myself, it's very, very clear that by and under the law, jurisdiction can even be conferred on this court because it relates to all the courts. Now,
इसका सिंपल मतलब ये है कि जब तक आपको jurisdiction नहीं है, जब तक आप सुन नहीं
the
सकते।
only restriction is in entry 55.
Yes.
It can be enlarged.
Yes.
No jurisdiction conferred under the Constitution can be curtailed or in any way interfered with by or under the law.
Yes. Let me
This is
just
how I
explain.
would read
Mr. Faisal, you haven't explained the entry. Yes, please, could you just take a little, time to just explain to such extent as expressly authorized? So where is it expressly authorized in the Constitution? Where is it under the Constitution expressly authorized that you could enlarge the jurisdiction under
May
184?
I explain that by reading a passage and then I'll state my argument. 2021.
So I take it that you agree with us that 175(2) does not confer jurisdiction.
It
or
does.
Competence.
No, it does.
Competence.
It does. It does.
Okay, you insist that it does.
No, I
confer
don't.
Competence, even if it is couched in negative terms.
I think negative is a relative word.
And it
If
would
it
have to
says
do-
no court, what
No,
else could
And,
be?
and
Let
since,
me- let-
no, and since law can here mean provincial law, it likewise confers it on provincial law. So what is then to prevent a province from saying, we are conferring a right of appeal on the Supreme Court relying on this 175(2)?
Because
Here is our law, we are conferring a jurisdiction.
because they would be barred under entry 55.
That's the whole point.
Yes.
That therefore validly enacted law.
Let me explain this. If I may
Very
read a
good.
passage, exactly the same problem came before the court. 2021 CLD 214, para 63. Both these provisions are dealt with.
Section 44 of the Competition Act के अंदर अपील है against the
तो
appellate
फिर उसमें
tribunal.
यही सवाल आ गया ना कि
मैं उस
Competition
पे
Act-
आता हूँ प्रोसीजर।
नहीं, ये जो कंपटीशन एक्ट ने अपील प्रोवाइड कर दी, जो सवाल ये है कि वेयर इज इट मेंशन्ड एक्सप्रेसली
जरा देखिएगा इसी
इन
में
द
जवाब
कॉन्स्टिट्यूशन
है।
फॉर
अगर आप देखिएगा इसी में जवाब।
कि 175(2) के तहत ही enlarge हुई होगी।
जी, अगर आप देखिएगा पैरा 62, it's the exact problem which her ladyship Justice Aisha Malik has dealt with. Exactly the same.
Para 62 is in
62.
which page? 293. 293. Thank you.
सर पैरा 62 में मैं पहला पैराग्राफ नहीं पढ़ूंगा। अगर आप देखिएगा एंट्री 55 रिप्रोड्यूस्ड है, ठीक, उसके नीचे मैं पढ़ रहा हूं। There are two parts to entry 55. Have your lordships found?
Yes.
There are two parts to entry 55. The first part allows Parliament to legislate on the jurisdiction and powers of all court in respect to matters in the FLL, which is the Federal Legislative List. The Supreme Court has been excluded from this part, meaning that Parliament cannot legislate on the jurisdiction and power of the Supreme Court in so far as the entries in the FLL. The second part of entry 55 deals with the enlargement of the jurisdiction of the Supreme Court of Pakistan and confirming of supplemental, please. Confer supplemental powers as well. Article 175(2) of the Constitution states that no court shall have jurisdiction save as is conferred on it by the Constitution or by or under the law. Article 175(2) of the Constitution gives Parliament competence to confer jurisdiction on the court by or under a law. The question is, does this include the jurisdiction of the Supreme Court? When Article 175(2) is read with entry 55 of the first part of the FLL and Article 142 of the Constitution, Parliament is competent to make law enlarging the jurisdiction of the Supreme Court and conferring supplementary power, which is provided by the Constitution, by or under the
By or under the.
yes, by or under the Constitution, meaning that the constitutional jurisdiction of the Supreme Court of Pakistan cannot be taken away, but where the Constitution authorizes on jurisdiction, it can be enlarged. So these are the two
question again is,
ये judgment, has it been assailed before this court?
Yes.
क्या हुआ उसका?
No, it's not suspended. I think leave grant to me.
इसे निकालिए, ये आप तो चेक कीजिए, ये इसके नंबर ले लीजिएगा, बता दें.
Sir, मैं भी CCP को उसमें leave grant के लिए suspend नहीं.
Is it unanimous or is it a unanimous judgment?
Sir, on certain issues,
On this issue.
on this issue, all three agree. All three agree. On this issue, which is given at the last para of her ladyship's judgment, अगर आप वो भी देख लें, उन्होंने बताया किस पे dispute है, किस पे नहीं है.
but Mr. Faisal, my problem with perhaps this judgment also, or otherwise, is that how do you pass this, the test of expressly authorized by or under the Constitution? So what I would understand from this is that somewhere in the Constitution, it must expressly talk about enlargement of the jurisdiction.
Not the enlargement. Not the enlargement.
वो बताएं।
Enlargement and supplemental are restrictions. Apart from that, you cannot. But enlargement of the jurisdiction and supplemental powers is the restriction imposed on Parliament's powers when it legislates on the jurisdiction and powers of the Supreme.
Let me just finish with this judgment. Can you tell us the background of this judgment? What had happened?
So, Competition Act है उसकी varies challenge हुई थी. And one of the provisions which was challenged was that how can a direct appeal be provided from a statutory body through a statute? That was one of the questions.
Sorry, come again.
So how can a direct appeal be provided to the Supreme Court through an ordinary statute?
It was to the Supreme Court.
Yes. And what is the legislative?
Against
Sir, Section 44
Yeah.
Competition Act.
against whose order?
Sir, वो
Competition
order
Commission
होता है Competition Appellate Tribunal का.
ट्रिब्यूनल के ऑर्डर के।
So in the nature of a service type matter, direct to the Supreme Court.
Direct to the Supreme Court. Election Act में भी है.
Huh?
But the
तो
question
order
which
हुआ
was
है।
answered was one of legislative competence. कि कहाँ से power आता है?
इसमें तो अगर आप देखें सिद्दीकी साहब आर्टिकल 185 में 185 में सिर्फ अगेंस्ट
Direct to the Supreme Court.
Direct to the Supreme Court. Election Act में भी है.
Huh?
But the
तो
question
order
which
हुआ
was
है।
answered was one of legislative competence. कि कहाँ से power आता है?
इसमें तो अगर आप देखें सिद्दीकी साहब आर्टिकल 185 में 185 में सिर्फ अगेंस्ट द जजमेंट ऑफ द हाई कोर्ट, लेकिन हम देखते हैं बहुत से कवानीन हैं जिसमें अपील की रेमेडी अगेंस्ट द ट्राइब्यूनल्स जजमेंट, अगेंस्ट द अदर फोरम जजमेंट, डायरेक्ट अपील टू द सुप्रीम कोर्ट. वो पावर्स जो दिए गए, क्या ये सुप्रीम कोर्ट की पावर जो आइन ने दिए हैं उससे हटकर मजीद पावर्स नहीं दिए गए?
That is not what is held in this judgment. But your lordship's question was, if I understand your lord, let's say, and the question before this
if
court,
you're if not understood, I will explain it. बात सिंपल सी है कि क्या जो मुख्तलिफ कवानीन के जरिए अपील की रेमेडी डायरेक्ट सुप्रीम कोर्ट में दी गई, जबकि सुप्रीम कोर्ट में अपील की रेमेडी 185 में है जो सिर्फ ये कहता है अगेंस्ट दी जजमेंट और ऑर्डर एंड डिक्री ऑफ द हाई कोर्ट. लेकिन हम देख रहे हैं बहुत से कवानीन है कि जिसमें हाई कोर्ट तो फैसला नहीं कि ट्राइब्यूनल्स उसके जरिए अपील सुप्रीम कोर्ट में आती है और वो तमाम एक्ट इनफील्ड है और उस पे अमल दरामद हो रहा है.
my lord, my submission on that, although that's a different question, but my submission on that is there is no such restriction in Article
There is
185.
enlargement of the jurisdiction of the high court or
Yes.
supplemental
See, the
powers.
question
So,
that
you
was
see, in
raised-
this case, the question was a larger question, and that was whether a federal law can enact and create a competition commission, whether there's competence to do so and whether they can make law on it. The argument was that actually this is a provincial subject and not a federal subject. Hence, the first part of the judgment deals with the competence of Parliament to legislate on the subject of competition. And in doing so, if it can create a regulator, the second part then says that it can also create this right to appeal. So it is not, again, it's not the same context as the case that we are hearing, because this is not creating an appeal to the Supreme Court. It is an appeal from an order of the Supreme Court, which is totally grounded in the Constitution.
But your ladyship has interpreted expressly authorized by or under the
Well, you see,
Constitution
I don't want to
as-
be explaining what I said, given that this is under
as
challenge.
meaning Article 75(2). That is exactly what Justice Hassan Azhar has
एक
done
चीज
in
मुझे बताएं
You're
what
putting
is
meaning to something that may not be there.
Faisal sir, just sorry, I'm not very familiar with this matter. If you can just tell us what was the objection who taken to this decision on this score? What was the other side's point of
The
view?
objection, I think, was that these are appeals to the Supreme Court which can only be created through a constitutional amendment. And this was one of the objections.
अच्छा ये बताएं कि अगर ये कानून में ये ऐसा
There were other objections.
if this law had said the appeal will lie to the High Court, it would have been okay.
This was not the objection. It was
Then-
that it's a provincial law and not a federal law. That was the objection.
I mean, the leave granting order also takes that as a question.
That was it. In fact, Mr. Bhandari even mentioned this the other day. This is precisely what the case was. He argued the case before.
चल हम देख लेंगे
And
उसको
try
हम-
hard.
But without any luck.
Right.
But the issue was that
It
when
was
it
on
comes,
who's competent, the federal government or the provincial government?
but when it comes to the interpretation of the words expressly provided by or under the Constitution, the
Mr.
only
Faisal,
article which
Mr.
this
Faisal.
judgment relies on
So-
is Article
so, Mr.
175.
Faisal,
Mr.
what I would like to ask repeatedly, the question is that whenever you set, is that how it is, that whenever you set out, law sets out to enlarge the jurisdiction of the Supreme Court, it is to pass the muster of these two conditions, that is, there must be an expressly authorized by or under the Constitution, which I don't know how it happened in the Competition Commission, but that aside. In this particular case, where is that express authorization or by or under the Constitution, which would allow the enlargement of the jurisdiction of 184? That's what I'm asking you, what does this line mean?
Sir, your lordship is reading the entire line without the comma.
Okay, so
So-
how do you want to
Yes.
read it? That's what I want to know.
If your lordship may kindly see that there is a comma before the enlargement.
Yes?
To such
So you're saying that
extent,
is separate, as a standalone?
that's a condition that you cross. You have to show an express authorization by or under the Constitution.
Where is that in this case?
That to me lies in Article 175(2).
Acha. Now, shall I read that?
no, Mr.
That is exactly what these two judgments say.
So
Mr.
judgment does
Mr.
not say
Faisal.
that, Mr. Faisal, आप उसको गलत, it goes under the federal legislative list. That's from where it derives its competence
Faisal,
as per this judgment.
Mr. Faisal Siddiqui, I'm here.
Ji, sir.
Yeah, the bare reading of Article 175(2) suggests there are two streams which are conferring jurisdiction of the court. One is the constitutional instrument and the other is the statutory instrument. दोनों स्ट्रीम से जुरिस्डिक्शन आ रही हैं. अब एक स्ट्रीम की दी गई जुरिस्डिक्शन से हम क्या दूसरी स्ट्रीम की जुरिस्डिक्शन को अमेंड कर सकते हैं या एनलार्ज कर सकते हैं? स्टैट्यूटरी लॉ के जरिए दी गई जुरिस्डिक्शन और एक कॉन्स्टिट्यूशनल लॉ के जरिए दी गई जुरिस्डिक्शन, दो जुरिस्डिक्शन है हमारे सामने. अब स्टैट्यूटरी लॉ के जरिए हम कॉन्स्टिट्यूशनल जुरिस्डिक्शन को एनलार्ज कर सकते हैं. नंबर वन. नंबर टू, दो लफ्ज इस्तेमाल हो रहे हैं बाय द कॉन्स्टिट्यूशन और अंडर द कॉन्स्टिट्यूशन. Do you agree that when a jurisdiction is to be conferred on any court, it is given by the constitution or by the law? And how it is to be regulated? The answer is under that statute or under that constitution provisions. The under is conveying the idea of how to regulate that jurisdiction. It is not merely implication.
of the law reforms ordinance. Now, Article 199, as His Lordship Justice Mandokhail pointed out, it's a constitutional judicial forum. Now, the
Yes, but
appeal
it is
under
safe in the
that is
Constitution.
provided under a statute.
You see,
If you're
Mr. Siddiqui, law reforms ordinance is a totally different species. It was a continuation of letters patent. It was a continuation of other provisions, and plus subsequently it was saved under Article 270. So, I mean, there are no parallels. You're comparing apples with oranges.
Sir, I'm comparing apples with apples, and I'll explain why.
Certainly, you're trying to do, but as far as I'm concerned, I'm so far.
Compare Granny Smith with Granny
Siddiqui
Smith.
Saab.
But the question, again, I mean, reflecting, adding to.
I'll
what
come
my
to the
learned
second
brother was
part
saying.
also.
You see, here you're creating a jurisdiction for the reason that the appellate jurisdiction is provided in 185. Fine. Now, 185 does not either talk of, it neither talks of an intra-court appeal, nor it talks of any other appeal envisaging something happening within the Supreme Court. What you're doing is, you're creating a new jurisdiction.
Yes.
You're creating,
Yes.
you're not enlarging. And when there is a creation, then the creation can't be done under item 55.
Enlargement of
And it cannot be done in exercise of powers under either 175(2) because that is also restrictive, and Article 191, that is also restrictive. So there are restrictions all over the place, and intentionally so.
My lord,
So that if an appeal be provided where the lawmaker or the framers of the Constitution consciously, deliberately did not provide one, then the matter should go back to them, and under the new circumstances, if they consider it appropriate, they can amend the Constitution and specifically provide an appeal. Using supplemental powers or using ancillary powers, I mean, that is, I think, stretching the Constitution much what it
my
is
lord, my
originally
response to
designed
the latter questions is there is no bar under Article 199. There is no bar under Article 185. There is no bar under Article 184(3) that you can't provide an intra-court appeal through an ordinary statute. There is no bar.
Mr. Faisal Siddiqui.
Where is the bar?
where the language used is express authorization. That is the bar. But you have to have express authorization within the Constitution in order to utilize.
What more
the
express
powers
bar is
available.
required than Article 175(2)?
175(2) does not confer
Mr. Faisal
legislative
Siddiqui,
competence.
if I may add to what my learned colleague is saying. See, it seems to me that the proper context of this sentence from this judgment at page 293 that you are so strongly relying upon, and with great respect, I think you're taking it out of context. But anyway, I think that is perhaps expanded upon at page 295.
सर पैरा अगर बता दीजिएगा
पेज 295 पैरा 63 इसमें जो अंडरलाइन पोर्शन है ना वो जरा देखें इसमें एक जजमेंट सुप्रीम कोर्ट की रेफर्ड टू है और उसके बाद उसका आई डोंट नो वेदर इट्स कोटिंग फ्रॉम इट्स कोटिंग फ्रॉम अ जजमेंट वो उसमें देखिए जिसको पैरा अंडरलाइन किया हुआ है जो
जी वो 2000 SCMR जो कोर्ट की
उसमें उसके अंदर शायद दैट एक्सपोर्ट्स दैट 175(2) पॉइंट इन प्रॉपर कॉन्टेक्स्ट पढ़िए तो सही सुशांत पढ़िए ये जो अंडरलाइंड है ना
Under entry 55
under entry 55 of the federal list.
I'm sorry, I actually have the
Page 295 जहाँ
अगर आप पैरा काइंडली अगर बता दें
पैरा 63 का सेकंड पैरा 63 सेकंड कॉलम थर्ड पैराग्राफ इसमें if the entry 55
if entry 55 was not there in the FLL, it could be argued that Article 175(2) of the Constitution in respect of matters relating to cooperative societies exclusively failing under the competence of the provincial legislature, a law can validly be made by the provincial legislature, enlarging jurisdiction of the Supreme Court and conferring on its supplementary powers. But Article 175(2) is not to be interpreted in isolation. It has to be read and interpreted along with Article 142A and the entries in the legislative list. Under entry 55 of the federal list, federal legislature is competent to make laws regarding jurisdiction and powers of all courts except Supreme Court with respect to any of the matters in such list. The other part of the entries makes the federal legislature competent to make laws enlargement of the Supreme Court and conferring thereon the supplementary powers with the proviso that this is to ascend is expressly authorized or under the Constitution powers powers and jurisdiction conferred on the Supreme Court by the Constitution can neither be inferred with or varied or taken away by legislature. However, jurisdiction of the Supreme Court can be enlarged and supplementary powers can be conferred on the Supreme Court by law in view of Article 175(2) of the Constitution and entry 55 read with Article 142A of the Constitution leaves no doubt that such enlargement of the jurisdiction and conferment of supplementary power can only be done through law made by federal.
So this is the point, I think. This explains the context of what that sentence says, because what this passage is telling us is that the jurisdiction of the Supreme Court can be enlarged. 175(2) does not do that, but for that there must be validly enacted law, for which you have to look not to 175(2) but to entry 55 read with the Article 142A. So this is the context.
142A says you look at the entry.
That's what I'm saying.
Yes.
The two have to be read together.
Yes.
But what this passage makes clear is
Yes.
that 175(2) is not a standalone power in jurisdiction, because at the beginning of this para, the Supreme Court gives the example, if that were so, which is what I also put to you, then law could include provincial law, and therefore a province could say, well, we enlarge the jurisdiction of the Supreme Court. Supreme Court is saying, no, that is not correct. That 175(2) is not independent. All that it tells us is, yes, jurisdiction can be conferred on any court, including the Supreme Court, by law, but that law has to be 55 and 142.
142A. There is no other third provision which is cited for the Competition Act.
लेकिन आप जो कह रहे हैं ना, आप जो उस जुमले को जो पढ़ रहे हैं at page 293 पे, as though that is intending to give a standalone competence in terms of 152. I don't think that's correct.
Mr. Faisal Siddiqui, if I go along with that, actually, so therefore, I don't understand how Competition Commission can confer a jurisdiction on the Supreme Court.
That's a big problem.
Unless it cannot, because it has to be, we have to pass through the same test as we have to pass today, that is expressly authorized or by or under the Constitution. So if 175 is out, then where is that expressed for, even for competition, election, or the other four different statutes?
There is
as well as
also a law,
184?
Faisal Siddiqui Sahab, there is also a law, Newspaper Employees Condition of Service Act 1973, in which also the appeal is provided direct to the Supreme Court. There is no appeal in the High Court, but it is against the conviction awarded by the Implementation Tribunal. So this is also direct appeal under Section 13A of the Newspaper Employees Condition of Service Act 1973. So competition, newspaper employees, contempt of court. There are three laws at least.
Yes,
And there are
yes,
two-
since nobody has given us me the background, there's a competition commission has given authority to the Supreme Court or the Act?
No, the Act. There is a provision, Section
Okay.
44.
And the argument from the other side is, since it is a provincial act, it cannot confer such jurisdiction. Is this the argument?
सर मैं हाई कोर्ट में नहीं था इसलिए मैं ज्यादा कहना नहीं
लिखा क्या
चाहूंगा।
जजमेंट में है उससे?
उधर एक
Since nobody has given us me the background, there's a competition commission has given authority to the Supreme Court or the Act?
No, the Act. There is a provision, Section
Okay.
44.
And the argument from the other side is, since it is a provincial act, it cannot confer such jurisdiction. Is this the argument?
सर मैं हाई कोर्ट में नहीं था इसलिए मैं ज्यादा कहना नहीं
लिखा क्या
चाहूंगा।
जजमेंट में उससे?
उधर एक ऑब्जेक्शन ये ली गई थी पिटिशनर्स की तरफ से।
One of the objection was how is a direct appeal provided in this one.
So,
The other was also about who has legislative competence,
It was
whether the
about
federal.
legislative competence.
Yes.
And in that context, the rest of the provisions of the law were challenged.
Yes, yes.
And so the judgment aims to show how the subject of constitution falls under the legislative list, and therefore from there derives power to.
Mr. Bhandari, were you the counsel in this case? Can you just explain me don't argue the case, just explain me the fact of this matter. What was the objection taken?
Well, to this particular provision, the primary objection was that under the scheme of the constitution, the High Court can't be bypassed in the appellate hierarchy. So the first appeal must be provided to the High Court under Article 185, to the High Court, and then from the High Court's judgment, the appeal should come to the Supreme Court. What has happened is
So that was the case. So
that was
if-
my
No, वो बाकी बातें नहीं, मैं सिर्फ ये I was just trying to understand the fact.
on the
Now-
question of appeal, that was the primary argument.
Just 1 second. Now, since the matter of competition, right? Since goods travel across borders and that's specifically permissible, mandated by the constitution. Now, if different competition commissions, even let's say there are 4 or 5 competition commissions in Pakistan, and matters start going to the High Court for different determinations, would there be fundamentally anything wrong if a province, for the sake of argument, or all the provinces confer the jurisdiction on the Supreme Court?
My lord, under the scheme of the constitution, that can only be done through Article 144.
Yes.
All the provinces will have to pass resolutions for an act of parliament to be framed in terms of Article 144. And then that too would have to pass through the
Has
test of
happened in
entry
draft
55.
Draft में हुआ
जी,
था।
draft में.
Draft में ये
So
हुआ।
that could be done.
There is a possibility. The constitution provides a way out for that.
Okay, just wanted to understand it. Thank you.
Entry 55 problem would remain in terms of
Yes.
appeal to the Supreme Court.
Yes.
Yes, that
As
remains.
opposed to Parliament making a competition law is a separate question which could be addressed by
Ji,
144. But the question of an appeal from appellate tribunal to the Supreme Court, that would still be.
तो फिर entry 55 के
फिर
टेस्ट तो
entry
फिर भी
55
meet
का
करने
उसी
पड़ेंगे,
में।
meet
हाँ।
करने पड़ेंगे।
Entry 55 is
जी, वो तो
still in
करने
the
वाला
way.
इसका मसला solve
144 में भी जाएंगे तो entry 55 के थ्रू गुजरना
वही फैसल साहब से पूछ रहे 55 का टेस्ट क्रॉस करें।
Faisal Saab,
You are express authorization पे
Faisal.
बात नहीं पढ़
I have 2 questions. If 175(2) is read with entry 55, is that not sufficient authorization expressly given to the parliament? Second question is that the expression used in entry 55 is enlargement of jurisdiction. Can you give an example how the jurisdiction, there are basically 3 different jurisdictions of this court under the constitution. How can the jurisdiction be enlarged? Any example?
Sir, appellate jurisdiction enlargement, one of the forms of enlargement of appellate jurisdiction would be creation of a new appeal. I mean, how can that not be considered as an enlargement of appellate jurisdiction? I mean, your lordship is going against the settled principle of interpreting an
Counsel,
entry, which is
if-
a
if-
very narrow
if-
meaning given to a word in the entry.
If an appeal was provided or envisaged under orders passed under 184(3) in the constitution, yes. Now conferring a jurisdiction would essentially mean you are amending the constitution.
Where is the bar in 184(3) that no appeal can be provided by an ordinary statute? Why
Where
don't you?
is the
there is no-
authorization?
no.
When
Learned
you-
counsel,
when-
let's-
when-
let's-
When you need to provide an appeal or an enlargement, you have to fall on entry 55.
Yes.
And entry 55 says there has to be an express authorization. So that takes care of where is the bar.
So you
Bar
say-
is there because it says you have to have express authorization within the constitution.
There,
Take a break and come back.
yes.
Is
Mr.
this a good?
Siddiqui, Article 10A has any connection with conferring power to the Supreme Court regarding appeal?
Sir, I would not like to go down that route that fundamental rights can be used in order to conferring legislative power because fundamental rights are so widely worded that the entire legislative list will disappear if that interpretation is.
10 past 2, we will convene
जी,
again.
जी, sir.
ठीक है, 10 past 2.
Thank you, sir.
Thank you.
सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ दरखास्तों की समाअत जारी है। चीफ जस्टिस काजी फायज ईसा की सरबराही में फुल कोर्ट समाअत कर रहा है। इस वक्त
Conferring power to the Supreme Court regarding appeal.
Sir, I would not like to go down that route that fundamental rights can be used in order to conferring legislative power because fundamental rights are so widely worded that the entire legislative list will disappear if that interpretation is.
10 past 2, we will convene
जी,
again.
जी, sir.
ठीक है, 10 past 2.
Thank you, sir.
Thank you.